Hello again. My name is Frederik Harhoff. I'm Professor Emeritus at the University of Southern Denmark. Last time we talked a little about the actors and the subjects of international legal order. Today we're going to talk about jurisdiction of the state. Now, we did discuss in the last session that the necessary elements of a state must be a fixed territory and a permanent population, and also institutions that are able to set out the laws that apply on the territory of the state. So this is what jurisdiction is really about. Jurisdiction is Latin and means basically the ability to set out the law. Now, when the legislative authorities of a state passes acts and legal rules that apply on the territory, then of course it means that these are the rules that apply within the country, and that we have executive authorities that can actually make sure that they are carried out in life, and can also correct mistakes. They can even arrest people if they violate the laws, and they can make sure that the laws are given effect according to their purpose. And finally, we have judicial institutions that can then finally and authoritatively determine how the laws are to be interpreted and what happens if the rules are violated. So that's what jurisdiction is basically about. We normally distinguish between civil jurisdiction and criminal jurisdiction. And let me begin with civil jurisdiction. Because, of course, the laws that that are passed by Parliament and apply on the territory apply to everyone who is present on the territory. It goes for citizens as well as non-citizens. It goes for people who are there permanently or for people who are there just passing through the territory. And so all persons are the subjects of the international legal order that is applicable within the territory of the state. With a few exceptions we shall see next time when we speak about immunity. Diplomats and others are exempted from this obligations of the legal system. But again, back to civil jurisdiction. Civil jurisdiction means the ability of the state to regulate any activity that takes place on its territory, and regardless of who is performing these acts. So everybody who is present is obliged by the legal system. Now, what happens if acts are committed by Danish citizens abroad? Does Danish jurisdiction extend beyond the borders of the Danish state? And the answer is yes, it does. Danish jurisdiction applies to a large extent to Danes who are present on the territory of another state. Why is that? Well, the idea is that you are not supposed to escape the obligations of Danish law just by moving to a foreign country. If you're a Danish citizen, then you are obliged to follow Danish law no matter where you are. So in principle, all Danish laws apply also to Danish citizens, and not only Danish citizens, also Danish companies who have been registered with their main seat in Denmark. So individuals as well as legal subjects, legal persons, physical persons and legal persons that are Danish are required to abide by Danish law no matter where they find themselves. Then what about the execution, and what about the competition between the obligations that, let's say, a Danish couple that moves to Germany, are they still bound by Danish law? And we have, yes, they are. But what about competing requirements imposed by German law? Are they also supposed to abide by those laws? And the answer is yes, of course. To the extent in which Danish law may conflict with German law, then of course it is always the priority of the host state that its laws should apply. So Danish law shall have to abide, to give in to German law in case there is a conflict of laws. But that happens rarely. And if there is such a conflict, then Danish authorities cannot correct the acts of the Danish citizen until they return to Danish territory. So once they come back from Germany, where they have performed acts that are in contradiction of Danish law, we can't touch them until they come back, and then we can prosecute them if necessary. So all acts that are covered by both laws, then Danish subjects will have to abide by both laws if possible. This goes for tax law, for instance, family laws, laws of inheritance. All of it applies to Danish citizens no matter where in the world they are. So if a Danish couple moves to Germany or to Indonesia and they have 2 or 3 kids, then the kids will be covered by Danish inheritance law. So once their parents die, they will become, they will be the heirs, and will have to, they can inherit whatever fortune their parents left under Danish law, and not under Indonesian law. So they will be covered by Danish law until their parents die and they take over the properties. So much for civil law applying where Danish law can apply abroad outside the Danish territory. If you look at the sea, then if there's a ship that sails around in the high seas, but under Danish flag, then we normally say that the ship is a part of the floating territory of Denmark. So all acts committed or performed, carried out on a boat that sails the high seas under Danish flag will also be covered by Danish law. For instance, if a couple wants to marry on board a ship that is out on the open seas, then that marriage will be covered by Danish marital law, marriage laws. So, ships sailing around under Danish flag are also part of Danish territory. Then let's have a look at the criminal jurisdiction. Criminal jurisdiction applies, of course, first of all, again, within the Danish territory. So any crime committed on Danish territory will be covered by the Danish Penal Code and can be prosecuted by Danish authorities and eventually by a Danish court, a criminal court. But what about acts taking place outside the territory of Denmark? Here we say that acts that have a direct effect and consequence on Danish territory, even if they are committed abroad, are also covered by Danish criminal jurisdiction. And the example that we normally use is the example where someone standing on the German side of the border shoots with a gun across the border and kills a Danish, or kills someone who's standing on the other side, on the Danish side of the border, and the person drops dead. If the perpetrator of that killing later on comes to Denmark, then we will arrest him and prosecute him for murder. Why? Because the act of shooting had direct and immediate consequences on Danish territory. So we will assume that the shooting, even though it took place in Germany, was almost the same as if it had taken place on Danish territory. And the German authorities, of course, will accept that. Now, further on, if we take acts that are committed not only that take immediate effect on Danish territories, but acts that that have an impact on Danish constitutional interests or security interests, even though they are committed further apart, they can also be prosecuted in Denmark if the perpetrator comes to Danish territory. For instance, espionage or contraband or anything that has been planned abroad but has an impact on Danish security and the Danish constitutional interests. If the perpetrators come to Denmark, then they will be prosecuted here as well. Now, in both criminal and civil law, the common feature of these two pieces of jurisdiction is that they all have a relation to Denmark somehow. Either the perpetrator is Danish or the effects are taking place on Danish territory. What if a crime is committed by a person who has no connection with Denmark whatsoever, and the effects of the crime are also completely outside of the scope of Danish jurisdiction? Can a person still, if he comes to Denmark, be prosecuted for the crime? And the answer is yes. That goes, for instance, for war crimes, because for these war crimes, we have established what we call universal jurisdiction. Universal jurisdiction means that any country, anywhere in the world, is not only entitled to, but obliged to prosecute a war criminal or a person who has committed a crime that is subject to universal jurisdiction. So all states have an interest in prosecuting a perpetrator who has perpetrated a crime coming under universal jurisdiction, because simply the international community thinks that these crimes are so grave that they have to be prosecuted no matter where in the world it takes place. So if a war criminal, for instance, in the ongoing war in Ukraine, if a Russian or Ukrainian citizen who has committed a war crime on Ukrainian territory comes to Denmark, then we are obliged immediately to arrest him and put him before a Danish judge in a criminal case. Now, of course, Ukraine or the country of the person can require then that we should transfer the person back to either Ukraine or Russian, depending on who he is, and we will normally abide by such a request and send him back to either Germany or Russia or whatever, because in the end it is a very complex situation to have a criminal case running in a country where there are no aspects and no elements of the place where the crime took place or the perpetrator. So we will be very happy to return but if no country requires the return of the person, then we are obliged to prosecute the person and put him in jail here in Denmark if he is found guilty. Thank you so much for this time, and next time we will be speaking about immunity. Thank you.